Hi students, I am Dr. Velavan, Faculty School of Management, Shastra, Deemed University. Now we are going to discuss about the cancellation of insurance. Okay, here we have to know where the policy will cancel. Okay, the policy may be cancelled by the insurer by sending to the insured 7 days notice of cancellation by recorded delivery to the insured last known as known address, and the insurer will refund to the insured the pro rata premium for the balance period of the policy. Okay. The second point, a policy may be cancelled at the option of the insured with 7 days notice of cancellation, and the insurer will be entitled to retain premium on short period scale of rates for the period for which the cover has been in existence prior to the cancellation of the policy. The balance premium, if any, is refundable to the insured. Third one, a refund of premium will be subject to there being no claim under the policy and the retention of money, minimum premium as specified in the tariff. The policy can be cancelled only after ensuring that the vehicle is insured elsewhere, at least for liability only cover, and after surrender of the original certificate of insurance for cancellation. The insurer should inform the Regional Transport Authority (RTA) concerned by recorded delivery about such cancellation of insurance. Now we discuss about termination of insurance. Okay, what is meant by termination? What are all the circumstances the insurance is going to be terminated? A contract of insurance can be terminated in the following circumstances. One is at the option of the insurer. Second one is at the option of the insured. Third one is due to existence of two. Insurances for the same vehicle. When they have taken two insurance for a same vehicle, now the insurance may be terminated. Okay. If it comes to the knowledge of the insurer or the insured finds that there are two coexisting policies for the same vehicle for the same period, the one which was taken first remains, and the other policy gets cancelled. Okay, the first one will remain, the other policy gets cancelled, and the premium is refunded by retaining a normal amount towards administrative and documentation expenses. Okay, the retention of minimum premium is necessary in the event of cancellation to take care of administrative expenses. Okay, then cancellation option of insurance policies. Okay, what are all the possibilities of cancellations, or what are the options are there? Okay, at the option of the insurer, okay, 7 days notice by a registered letter to the insured at his last mentioned address. Okay, they'll send a notice to the insured. I think it's a 7 days prior notice. The insured is entitled to refund of premium for an expired period, and the insurer retains the premium for expired period proportionately. Then the second one is at the option of the insured, 7 days notice, and the insured is entitled to refund of premium on the number of expired days, and the insurer will retain the premium for the period during which the risk was in force more than proportionately on short period basis, provided no claim has been preferred by the insured. Third one is no cancellation is allowed if the ownership of the vehicle is transferred to the new owner unless the evidence of from policy for the vehicle is produced. Okay, this is called what termination of insurance. Okay, the next one is insurance policy in terms of transfer of policy. What are the conditions here we have to cover? Okay, number one, in the event of the death of insured On transfer of ownership, the liability only cover either under a liability only policy or under a package policy is deemed to have been transferred in favor of the person to whom the motor vehicle is transferred with effect from the date of transfer. The transferee shall apply within 14 days from the date of transfer in writing under recorded delivery to the insured who has insured the vehicle, with the details of the registration of the vehicle, the date of transfer of the vehicle, the previous owner of the vehicle, and the number and date of the insurance policy, so that the insurer may make the necessary changes in his record and issue the fresh certificate of insurance. In case of package policies, transfer of the owner damage section of the policy in favor of the transferee shall be made by the insurer only on receipt of a specific request from the transferee along with the consent of the transferor. If the transferee is not entitled to the benefit of no claim bonus shown on the policy, or is entitled to a lesser percentage of no claim policy than the existing in the policy, recover of the difference between the transferee entitlement, if any, and that shown on the policy shall be made before effecting the transfer. A fresh proposal form duly completed is to be obtained from the transferee in respect of both liability only and package policies. Okay. Transfer of package policy in the name of the transferee can be done only on getting acceptable evidence of safe and a fresh proposal from duly filled and signed. The old certificate of insurance for the vehicle is required to be surrendered, and a fee of ₹50 to be collected of issue of fresh certificate in the name of transferee. If for any reason the old certificate of insurance cannot be surrendered, a proper declaration to that effect is to be taken from the transferee before a new certificate of insurance is issued. Okay. The policy will lapse after 3 months from the date of death of the insured or until the expiry of the policy, whichever is earlier. Otherwise, the legal heirs can get the policy transferred subject to their application with the following. One is death certificate of the insured and the legal heirship certificate, proof of title to the motor vehicle, and copy of the policy. Okay. The insurance company reserves its rights to abide by any order of the court with regard to declaration about the legal heirs and ownership of the vehicle, and the nominee will not have any right to the order of the court. Okay. Then the next one, in case of change of ownership, the policy benefits stand to accrue to the buyer of the vehicle once sale consideration is paid and a suitable endorsement made in the certificate or registration provided the transfer of insurance from the original owner to the new owner is done within 15 days of the sale. As per Motor Vehicle Act, if not done, the accidental benefit to the damage or loss of vehicle is forfeited on the 16th day itself, but the Act is generous towards their party liability. The double insurance. When two policies are in existence on the same vehicle with identical cover, one of the policies may be cancelled. Where one of the policies commences at a date later than the other policy, the policy commencing later is to be cancelled by the insured concerned. If a vehicle is insured at any time with two different offices of the same insurer, 100% refund of premium of one policy may be allowed by cancel that later of the two policies. However, if the two policies are issued by two different insurers, the policy commencing later is to be cancelled by the insurer concerned, and the pro rata refund of premium thereon is to be allowed. If, however, due to requirement of bank, financial institution, intimated to the insurer in writing, the earlier dated policy is required to be cancelled. Then refund of premium is to be allowed after retaining premium at a short period scale for the period the policy was in force prior to cancellation. In all such eventualities, the minimum premium as specified in the tariff is to be retained. In either case, no refund of premium can be allowed for such cancellation if any claim has arisen on either of the policies during the period when both the policies were in operation, but prior to cancellation of one of the policy. Okay. The next one is cancellation and insurance of fresh certificate of insurance. Here we know following any changes in the policy during its currency affecting the information shown on the certificate of insurance, the certificate of insurance is required to be returned to the insurer for cancellation, and a fresh certificate incorporating the changes to be issued. Information regarding changes of number of engine and or chassis of a vehicle is required to be intimated to the insurer immediately for effecting necessary changes in the policy, provided such changes are duly endorsed on the registration certificate. The certificate of insurance is also required to be returned immediately for insurance of fresh certificate of insurance incorporating the changes. The remittances of Rs 50 is required to be made to the insurer for each insurance of fresh certificate of insurance. Okay, each issuance of fresh certificate of insurance. Okay, you have to pay, because we have to pay. They charge 50 rupees for issue of a fresh certificate instead of the old one. Okay, and the next one is what? Policy renewal. So when we go for renewal of a policy, the document is issued in lieu of policy at renewal. The issue of receipt shows that insurer has received the renewal premium and has the policy renewed for further 1 year. A fresh policy has to be taken if the renewal is not under the same conditions as the old policy. Okay. Additional policies to be taken along with motor insurance. The personal accident insurance, number one is personal accident insurance. Insured can choose to take personal accident policies for the occupants of the vehicle, including owner and driver. The additional premium is being charged based on the personal addition, PA table selection. It can be given for unnamed occupants too. Premium for per annum, I think, okay. Premium for increased liability against third party property or unlimited insurance for legal liability. So legal liability is for consideration by the insured. Then commencement of risk. The risk commences immediately on the issuance of insurance policy. The details of policy and what is contained are given as under. The next one is concession for vehicle laid up. Okay. If a vehicle is laid up in a carriage and is not put to use for a continuous period of more than 2 months, the liability of the insurer under the liability risk section of the policy is suspected for such period, and a concession is given to the insured. The concession is given into 2 forms, and the insured can choose whichever he wants. Pro rata refund of premium for such period. This refund is granted in the form of credit and not as a cash. Such refund can be adjusted against the premium for subsequent renewal. Second one is the policy period can be extended after the expiry of the policy for a period equal to the period of such layup. Under accidental damage section, the cover is suspended for the period during which the vehicle is laid up in carriage and not in use, and not in use. And the restricted cover for fine and or theft is granted for the period of layup, and a refund of a premium on pro rata basis is made after charging a premium for the restricted cover. Again, the refund is on credit basis and not cash. Okay. As an alternative, the insured can extend the policy period after the expiry of the policy for a period equal to the period of layup. A notice in writing must be given to the insurer regarding the layup, and the certificate of insurance must be surrendered. Such layup of vehicle must not be meant by repairing the vehicle. The period of suspension of cover shall not extend beyond 12 months from the expiry date of the policy. Forms of loss. Direct loss or damage to the insured vehicle resulting from accidental means caused by insured per approximately. Indirect loss and damage damage to the insured by legal liability. Direct loss and or damage. It refers to physical loss of the property, that is vehicle by way of theft or physical damage to the vehicle due to accident. Okay. Then indirect loss and or damage. As a result of accident, the owner of the vehicle may be made legally liable to compensate the third parties for their death and bodily injured and properly damaged. Such compensation is called liability arising out of use of vehicle in public place. It means the insurer meet the legal liability payable by the insured to a third party due to accident. Okay. Third party means any person other than the insured and the insurer. The liability means the amount of financial compensation legally payable by the insured to the third party. Okay. The next point is liability for third party limit. Under section 2, subsection 1, subclass 1 of the package policy, under section 1, subclass 1 of the liability only policy, as per requirement of Motor Vehicle Act 1980 is unlimited. Under section 2, subsection 2 of the package policy, under section 1 and 2 of the liability only policy, rupees 7.5 lakhs, rupees 5 lakhs, 7.5 lakhs. Okay. Rupees 6,000 where the proposer are insured up to limit for TPPD liability to the statutory limit of rupees 6,000. Then endorsement of IMT 20 is to be used. This is also very important. Then from the past experience, a few instances of proximate causes are given as under: damages to vehicle whilst attempting to save a cyclist or pedestrian. Then damages resulting from bursting of tires, damages resulting from mechanical breakdown, damages to vehicle due to skidding in the heavy rain, small vehicle hit by over speeding heavily vehicle, small vehicle hit by over speeding heavy vehicle, then vehicles damaged and whilst in the parking place, then accident due to animals, damages due to poor visibility owing to fog and bad roads, then overturning by hitting trees or parapet or road dividers and other stationary objects, then accident to vehicle due to pits on side of the road by public authorities. The next one is duties of the insurer. Duties of the insured. The following are the duties of the insured. Okay. Duty of the insured to do his best to avert or avoid or minimize loss. Okay, this duty arises from the duty of good faith he owes to the insured, and more usually from the express conditions of the policy. If accident is caused by fire or collision or any external means, he must take such measures as are reasonable to extinguish the fire or to prevent further loss by removing the vehicle to nearby safe places. He is not to interfere with the efforts of other persons engaging in helping to reduce or minimize loss. Then fourth point is, for the purpose he should take steps to remove the vehicle insured to a place of safety unless he finds that all hopes to save it will be useless. If his failure to perform these duties is willful, it may be an evidence of fraud and disentitling him to recover anything on the policy. It has become an absolute necessity that the insured complies with the conditions imposed by the insurer, which are embodied in the policy form. Okay. The next one is duties of the insured prior to the occurrence of loss. Okay. The following points here we need to understand. He should take reasonable steps to safeguard the vehicle from any loss or damage and act as it uninsured. And the insured should maintain the vehicle in the most efficient and roadworthy condition. The company, as at all times, shall be at liberty to inspect and examine the vehicle and any part of the vehicle, and also any driver or employee of the insured. Okay, so these are the point we have to know. Then after the occurrence of accidents, what we have to do? Okay, it is a duty of the insured to exercise care and concern in the event of accident, and also at the time of breakdown of the motor vehicle. This is point number 1. It is a duty of the insured to exercise care and concern in the event of accident, and also at the time of breakdown of the motor vehicle. B, the insured should exercise duly diligence and precautions to ensure that the damaged vehicle is immediately attended to, so that the aggravation of further loss and deterioration to the damaged vehicle is prevented and avoided. C, any aggravation of damages due to non-attendance, non-repairing the damaged vehicle, or driving the vehicle without repairing the damage amounts to falling from the duties of the insured. The insured is solely responsible for such lapse and will be made to bear the loss or damage. Notice of the loss to be given immediately to the insurance company. This is the next point. Then the insured should extend all assistance and furnish necessary information with regard to the claim. And all legal documents such as letters, rights or claims, summons received should be immediately forwarded to the insurance company. A notice shall be given with regard to any prosecution or inquest or fatal injury to the insurance company. The insurance should lodge FIR with the police authorities with regard to theft or criminal acts which may lead to claim. The insured should also cooperate with the insurance company in securing the conviction of the offender. So these are all the points we have to carry out, we have to do after the occurrence of accident. Okay, these are the steps we have to do. Okay. The next one is legal procedure. In case there is any contributory negligence with regard to third party claims, the insured should not make any admissions or offer or promise for payment of indemnity to any third party without the consent of the insurance company. This is one of the legal procedure. The second one is, if necessary, the insurance company will conduct the defense in settlement of claim, legal proceedings and prosecution on behalf of the insured. The insured should extend all assistance and cooperation to the insurance company. So these are all the legal procedure we have to follow. The next one is settlement of the claim at the option of the insurer. The insurance company has to option to either allow the insured to repair the damaged vehicle or reinstate the damaged parts or replace the motor vehicle or its accessories. Okay, the payment may be made by cash. The second point is regarding here, the insurance company will pay for the loss or damages and also reasonable cost of listing such damaged parts or labor charges included. And third one is, such payment shall not exceed the sum insured, which is the estimated value of the vehicle chosen by the insured at the time of taking the policy or renewal, provided the market value of the vehicle included accessories is not less than the estimated value of the insured. So these are the points we have to be followed at the time of settlement of claim. The next one is the application of principle of contribution due to double insurance in the event of claim. In case of double insurance, the insurance company will pay only its rateable proportions of the loss or damage or any compensation or cost or expenses. In case the insured is having more than one policy for the same vehicle with different insurer, each insurer will pay only in proportionate to it. Sum assured. The next one is the reference to arbitration in respect of a dispute in admissible claims with regard to quantum difference. Dispute regarding the quantum of loss or damage where the insurer admit liability shall be referred to arbitration. The arbitration proceedings are discussed in details in the next chapter. Okay. Then time limit for filing suit in the court of law. If the insurance fails to protect any claim within 12 calendar months from the date of rejection of liability, the court of law, the insured losses the rights of remedy. Okay. Insured lose the rights of the remedy. Okay. The next one is observance of fulfillment of terms and conditions of the policy. Since the policy terms and conditions are given in the policy based on the true information and the details given by the insured, to the best of their knowledge, the insured is bound to comply with the same, and such compliances shall be the conditions precedent to any admissible liability under the policy. The contract of insurance of it subject to implied and express conditions which expect the insured to observe the conditions precedent and conditions subsequent. So these are all the points we discussed regarding transfer of policy. Okay, and regarding motor insurance policy. Okay, good. The next topic we are going to discuss is what? Common exclusions that are applicable to all type of vehicle in the event of claim. The common exclusions that are applicable to all type of vehicles in the event of claim. This is also very, very important. Okay. Number one is geographical area. And here the vehicle sustains damages or the vehicle is lost, and if any liability is incurred, that should have been only due to an accident that take place within India. This is number one. Number two, contractual ability is executed. Number three, no insurance claim is payable if the insured violates the conditions of limitation as to use. If the vehicle is driven by any person other than the driver whose name if any is specified in the policy, and the insurers will pay only for the resultant damages or loss, and no liabilities arising directly and indirectly are contributed by igniting radiations or contamination by radioactivity from any nuclear fuel or unclear waste from the combustion of nuclear fuel. The damage caused by nuclear weapons material is not admissible. No claim due to war, warlike operations. Action of terrorism are excluded. Okay. Then role of surveyor. This is also very, very important. The role of surveyor. Okay. Surveyor are being authorized and placed in different categories depending on their professional qualification and special competence gained by experience. Once they are empaneled, their services are being utilized by insurance companies operating in India in a different field of working. They play a very vital role in the insurance field, not only prior to the acceptance of risk, but also after the occurrence of loss. Insurance companies, after the occurrence of loss. Okay. The insurance companies are utilizing the services of surveyor for pre-inspection of major risk and for the assessment of insurance liabilities. The remuneration or fees depends on the quantum of assessed admissible liabilities of insurers. Any association or group or a firm or an individual can become surveyor provided they have competence in the field like chemical engineering, automobile engineering, and chartered accountancy, etc. What is expected to surveyors? They should develop their product knowledge or insurance based on their specialization and keep on updating the changes. This is number one. They should develop their product knowledge or insurance based on their specialization and keep on updating the changes. Second one is they should be highly competent in handling the assessment given by insurers and be helpful both to their insurer and the insured. Third one, they should be neutral, unbiased, and free from prejudice in their approach towards the customers while handling the claims. Their attitude should be polite and their decision firm in respect of the assessment. They should exercise due diligence, care while assessing the quantum of liability, and in the process the concern towards the interest of the policy holder should not be lost. The duties of the surveyor should be discharged scrupulously, and the honesty and integrity should be maintained at the highest degree. The surveyor should remember that he is independent and his role is indispensable to ensure that the promise of both parties are fulfilled. Then functions of surveyors in motor insurance. The job of the surveyor begins as soon as the allotment of survey is done by insurance company. He should collect the necessary work allotment for each job along with claim papers, such claim intimation letter of the insured, estimate of the repairs submitted by the insured, and a copy of the relevant policy. And the surveyors should immediately reach the spot of accident and advise the insured to remove the damaged vehicle to the safe place or reputed workshop. He should adjust the insured of, if necessary, to lodge the FIR and produce the vehicle to the RTO authorities. He should take necessary photocopies of the damaged vehicle. This is also very, very important, because they will assess based on their based on the surveyor's document. Okay. He should ascertain the actual cause of accident and the extent to which part of damage. His primary duty is to estimate on his own the like expenditure towards the cost of labor and cost of parts to be replaced if required. The surveyor should negotiate with the repairs and accurately decide the quantum of liabilities without letting the repairs to manipulate the cost of repairs by inflating the bills, and also estimating the parts replacement which are repairable at the minimum cost. The surveyor should justify that the cause of the loss is due to insured perils and the extent of damage is in conformity with the nature of accident that took place. The surveyor should conduct the survey at the repairs workshop immediately and permit the repairs to dismantle the vehicle in the presence, very careful to find out the external internal damages, if any. There should not be any communication gap between the surveyor and the repair, as well as the surveyor and the insurer. The surveyor should keep the insurers informed about the development of the claim periodically, and keep the insured posted about what he has discussed with the repairs with regards to accidental repair works to be carried out. The next part is, he may have to verify the bills of the parts to ensure that avoidance of inflated bill by the repairs. The surveyor should finalize his report with regard to the admissible liability in respect of cost of repairs, labor charges, replacement of parts, and the value of salvage. He should ensure that the report is concluded after inspecting the repaired vehicle, so as to confirm that the repairs have actually carried out replacement of new part and other repair work as agreed by repairers. The report should be submitting with these new recommendations confirming the genuineness of the claim, the authenticity of approximate cost, and verification of vehicular records. His report should be submitted at the earliest so that the insured does not suffer under any circumstances for want of financial assistance. So these are all the duties of the surveyor in motor insurance, my dear students. Functions. Okay. The next one is duties of the insurer. Okay. The first duties are is verification and recording of claim. Okay. It is the foremost duty of the insurer immediately when a claim is reported to verify whether the vehicle is insured or not, whether the premium is paid in advance before date and time of accident, whether the policy is in force or not. This is to ensure that the loss falls within the policy period, whether the loss and damage is caused by an internal peril as described as a policy. So these are all the points immediately he has to verify, then will proceed further. Then appointment of surveyor. On appointing the completed claim, for obtaining the completed claim form from the insured along with the estimate repairs, the insurer appointing the surveyor to assess the nature, cause, and extent of the loss and damage. Okay. Then collection of document. The insurer then collects vehicle record depending upon the type of vehicle lost and damage due to accident. It is mandatory to part of the insurer to fill the supplementary to the claim for statement of particular extracted after verifying the original vehicular record and such registration certificate. Then liaison. The insurer should liaison with the insured information in informing him to cooperate with the surveyor to submit the document required by the surveyor in order to release his survey report, and at the same time keep in touch with the surveyor, submit his report after satisfying himself with the all aspects of the claim. Then compliance. The insurer will ensure that the insured is complied with all the conditions under the policy and performed. Then valuation. This final duty. The insurer obtain the survey report and evaluate his liability, taking into account the survey report and bills submitted by the insured. Okay, he has to properly evaluate, and finally he will submit the report. The motor insurance claim. The claims arise when the insured vehicle is damaged and loss incurred. Any legal liability is incurred for death or bodily injured or damaged the property of the third party caused due to the usage of insurance. So these are the claims, or these are the situation for insurance claim. Okay. Thank you.